What's going on, everybody? TRAE4JUSTICE back in the building, coming at you guys with day 15. Now, this whole video is going to be day 15 in its entirety. It's pretty quick. I think it only lasted maybe an hour. It was a lot of breaks that were taken, but the main thing is that the verdict was reached today. So I mean, I know you all have seen it already, but yeah, Darrell, he finally gets what's coming to him. He gets a guilty verdict on all charges, and I could not be more happy. Okay, and the last thing I want to point out, the absolute sadness that just washes over Darrell as they read off all of these charges that he is guilty of. Oh my goodness, it's a masterpiece. He is stressed out. His eyes are like all watery and stuff because he's crying, of course, for himself. But since this is pretty much like one of the last parts of this series, I know there are victim impact statements, and I do want to react to that. I'm just figuring out how exactly I'm gonna do it right now. But the main thing I want to say before we get into this is thank you all so much. This series has been a blast. I got to watch this trial for the first time with you all, and I got the chance to learn a lot along the way. And so that is something that I can never thank you all enough for. But I don't want to hold you guys up. I just want to say thank you to a few people that donated, and then we'll get straight into it. So thank you so much to Serena Chapel for a 15-pound donation. I finally said it with confidence, 15 pounds. But thank you so much. I really appreciate it. And thank you for continuing to watch along and for sticking with me. Thank you so much to Becky Winkler for a $5 donation. I really do appreciate it. And thank you for continuing to watch along and for sticking with me as well. Thank you so much to Joyce for a $25 donation. I really do appreciate it. And thank you so much for continuing to watch along and for sticking with me. Thank you so much to Becky Booter for a $5 buy me a coffee donation. I really hope I'm saying your last name right. I'm sorry if I'm not. Maybe I should just say Becky B because I have no idea if I'm saying it right. But thank you so much for a $5 buy me a coffee donation. I really do appreciate it. And thank you for continuing to watch along. But most importantly, nobody has to send me a single thing. What I do want to say is if you would like to donate to the community of Waukesha and the actual victims, there are links pinned at the top of the comment section. So if you're looking for resources to do that, they are right there for you. All right, this is a bit of an emotional one. Without further ado, I hope you enjoy the video. Thank you.
We are back on the record in State versus Brooks. May I have the appearances, please?
It's time. Oh, it is time.
Thank you. And sir, for your appearance this morning?
Just 1 second.
No more seconds. No more time. Let's just pass them up. It's time to... Darrell, it's your big day, buddy. It is your big day. I really feel like he's stalling right now for that reason.
I apologize for that, man.
It's all right. When you're ready.
I'm here as third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
Thank you. The record.
Okay. I'm sorry. Do you see the amount of stress right now? Hold on. All right, I'm smiling a lot. I'm smiling a lot because I'm pretty sure it's written on the title. This is the day that the verdict is reached. So I'm thinking right now Darrell is pretty stressed because I think he knows, look, he is a very delusional guy, as we've learned throughout this trial. But I think even he knows he's going to get stuffed under the prison in the smallest cell they could possibly find to jam him into. So it's just insane. Like, he's stressed out right now. But yeah, let's see.
Reflect that the individual known
The
to
big
this
day,
case,
here it
Darrell
is.
Brooks, is present in custody in person. He is wearing his jail attire this morning. I do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open, and the jurors are here, and they will be instructed to start their deliberations.
Oh, they're already here.
The only other thing I would put on the record is I have received information regarding the Reddit post, that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding, based on news reports, that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record.
Figures.
And, if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information.
So,
go ahead.
So it's being called a prank.
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the Sheriff's Department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things, and will be available, of course, if there are any questions or if a verdict is reached. So notify the parties. Yes.
Oh, go ahead.
No.
Go ahead.
I'm still very concerned about this whole Reddit thing after having the chance to fully read it and look at some of the language that's in it.
Darrell, it's over. It's over.
It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the Sheriff's Department.
I would like Your Honor to, if it pleases the court, and if it pleases Your Honor, I would like to
Call for a mistrial.
look at some alternatives. If I may bring up the in regards to the language, I also want to state that for the record, this did not come about from the prosecution side, from the defense's side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information that had been known.
Here we go.
I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere.
Wait, I'm confused. Did she not inform everyone at the same time, like him and the prosecution? I'm pretty sure she walked out and said, oh yeah, we just found out that there's a Reddit post that says support Darrell or whatever it says. So it's weird. He's just trying whatever right now. Like this is his last lifeline right now, and it's not even there. There's nothing for him to use. But as we know, Darrell, just because there's nothing there to use doesn't mean he's not going to try. So we're going to have to deal with this until the very end.
Around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor,
address that for you right now if you would like.
Yeah, if it pleases Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to
He doesn't know.
look into a mistrial and also any alternatives along those lines, short of that or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody.
There it is.
And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being
Okay, before he gets into this randomness that he's about to spew out, can we just acknowledge really quick that he's able to, like, you see right now how he's able to calmly convey his messages to her without screaming or just being rude in general? Like, do you see right now how he's actually able to do it? I mean, I shouldn't say it's weird. We know Darrell will do whatever he feels like he needs to do in the moment to get out of a situation. So I guess it shouldn't be weird to me, but it's just crazy.
United States versus Perez, 22 U.S. 579, and that specifically, I think it's referenced because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references.
Sure, yeah.
In regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion.
Right.
And I think that's kind of like the leading one. Also, I looked at Brown versus Rushton, 572 F.3D 198, which speaks to the language is basically, it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES. 917.
Very important.
F2D 388. And that speaks of potential for an impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497.
Okay. Sorry to interrupt, but so as you guys know, my knowledge about like trials and case laws and stuff is not good at all. Like, I don't really understand much of it. But how much do you want? How much do you want to bet that none of this actually applies to what's going on right now? I can almost guarantee you that this is just some random stuff he looked up. It probably doesn't apply to the type of court this is, because from what I understand, there's state and then there's federal, I think. And so he'll use like federal cases as an example. So I'm almost sure that none of this applies to anything that's actually happening right now. But yeah.
And that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury which may be tainted by bias. And I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language, it's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at. Look at some options. Look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this.
I'm not sure, but I think he's extremely concerned. Just to guess.
Anything for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws and
What's the request, though, that you're making
right
based on the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
relief.
Relief?
Like, what are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to
oh no, he's just gonna run through the whole thing again.
A mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. it can start with something that's this small, and then it can snowball out of control into something totally different.
Okay, I have no idea what he means by that, but this Reddit thing is so important to him now that he's literally thrown out every other argument that he's had, and he's fully leaning on this Reddit post is so serious, you should just let me go home. Yeah, this Reddit post is, you can't take a risk on that, right? Somebody posted on Reddit, I gotta go. It's just crazy right now that this is really, this is all he has right now. I mean, it's not surprising, but it's,
I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent the who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
all right.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start, and that the original poster didn't think it would get that far out of hand.
Jeez.
The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
Well, there you go.
That on the grounds, Your Honor, that, like you just said, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue is put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room. They got certain feelings from when they specifically refer to themselves and a group. That would be we, plural.
Because anybody can't write that. Couldn't be anyone.
They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly. There's no other way to interpret this. You can tell by.
All right, can we cut him off now? Because we know what's going on. Like, we know he's just trying to talk everyone in circles so he doesn't go to prison too quick. But can we throw him in the other courtroom or something? Just because I got a feeling this is not going to stop. And when Judge Darrell inevitably cuts him off, he'll probably, in a last-ditch effort, throw a tantrum. So can we just nip this in the bud, get him in the other courtroom?
What they're laying out in the language that they're speaking with, if this is clearly someone close to the case, and because of that, it still has to be. I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks, and even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this there has to be some type of alternatives, and something has to be done. Something. And if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at, if anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, now all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Well, let me address your concerns, sir. I cannot make conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you, though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury. And I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the Clerk of Court's office receive emails regarding this, it sounds like the district attorney received emails. I may have even gotten one, I don't remember the time, it was later, regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it, and I simply forwarded that email onto law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits.
So just in case some of you haven't used Reddit before, because I use it from time to time, I don't use it too much, but it is a site where I could see something like this happening, where you have subreddits for various topics, and people could just do something like this, where basically pretending to be a juror or pretending to be someone else. So if you're somebody that's familiar with Reddit, you can see how this is actually insane, that he's trying so hard to use this as a way to get out of a trial. But okay, I just wanted to say that really quick.
And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks, so go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined, so I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the Sheriff's Department to make that available for you, should you choose.
Isn't it my choice?
Yes, it is.
So why do I need to be in street clothes? Why does that need to be on the record that
Your choice should be placed on the record, sir.
If or if not, I was offered to be in street clothes. If I made it the choice.
Do you dispute that, sir?
Yes, I dispute it because it's my choice.
Well, no. Do you dispute that you were given the choice this morning?
At this point, there's no reason why that should be on the record. That if
A new angle has been brought up. So now he's going to argue about his street clothes. Here we go. He's winding up right now.
or if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if
Why?
you were to challenge that you and claim that you were required to wear your jail uniform or jail attire. You're not required. This is a trial. You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just indicated why, sir. So
I don't see the relevancy of it.
all right. At this point, unless there are any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The court declines that. I'm stepping off.
Why hasn't it been proven on the record yet? And I object.
Oh man, he has nothing else. There's nothing else left up his sleeve. After the Reddit thing was completely shot down, he goes back to what he knows best. Subject matter jurisdiction. And it never works. So I'm surprised that, well, maybe not surprised, but it's just weird he keeps going back to it. It's not going to go anywhere. But okay, I'm going to jump forward. This might be the moment the verdict comes in when I go for it. So I'll be right back.
State versus Brooks appearances are as they were before. I would make just one note that Mr. Brooks is now present in a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter. And
this is really it.
Without anything further, I'll have the jury brought out.
Oh my goodness, this is it.
Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record that has yet to be proven.
It does not
Objections
matter.
are noted. I will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
He's going to try to really freak out now in hopes that the jury gets sent back in.
Reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
You know, I actually purchased confetti for this moment. I was like a handheld confetti.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
Please ignore him.
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. I will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor. Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor? For the record, may I request the legal or factual basis for your ruling, Your Honor?
I love that she's not answering. The silence.
It might have been a false alarm.
For the record, may I respectfully request a written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor? Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant?
I love how the jury is fully out now.
Admiralty law or common law, if this court is operating under admiralty law?
I will not be addressing any of those issues. Thank
Respectfully
you, everyone.
object,
Please be
Your Honor.
seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson?
Here we
All
go.
right, and I see it's juror number 11. Have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff?
But I purchased like a little confetti cannon or something for this, and it's actually coming 2 days from now, so it's not gonna get here in time. But I didn't want to keep holding you guys up, so here we are. I was I was gonna shoot some confetti as soon as they give him the old verdict here. He's gonna say something. He's thinking.
Your Honor, seeing as that we've reached the verdict, is it necessary that I have these shock devices on my ankles?
Is that supposed to move us to change our verdict?
And I have confirmed that there are 76 signed verdicts and 76 unsigned verdicts, which would be what I would expect. All right, I will read each one into the record.
Okay.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that.
I completely forgot that happened. I forgot.
We, the jury, find the
I second
defendant,
that,
Darrell E.
but-
Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information, dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Okay, there it is. I mean, that's not all of the verdicts, but I just want to get a screenshot real quick of him doing this because this is like, it's insane. I knew that this was going to happen, but I'm still feeling like emotional at the fact that we finally got to this point. All right, I'm not going to keep it
We, the
paused.
jury, find the defendant,
Man.
Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 9 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 10 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 11 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 12 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 13 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 14 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 15 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 16 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant guilty of first degree recklessly endangering safety as charged in count 17 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 18 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 19 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 20 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 21 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 22 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 23 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 24 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 25 of the information. Dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 26 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 27 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 28 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 29 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 30 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 31 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 32 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 33 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 34 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 35 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 36 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 37 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 38 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 39 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 40 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 41 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 42 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 43 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 44 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes.
Okay, sorry I'm pausing. I said I wasn't going to pause at any point, but I'm thinking he's just going to get a clean sweep here, like he's just going to get a guilty verdict on every single one of them, which is amazing. Man, and look at how cowardly this is. Even at the end, he can't even just face what's happening right now. He has to sit here, cover his face, and pretend like it's not happening. In my mind, I was thinking that once this happens, I was going to be like really upbeat and happy about it, which like I am. But at the same time, it had me tearing up for a second there. Like when you actually start to hear her list off what the charges are, and then, yeah, but this is a great moment.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 45 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 46 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 47 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 51 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 54 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 60 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes.
So far 60, and he's guilty of
We, the
everything.
jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 61 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 62 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 63 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 64 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 65 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 66 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 67 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. Did the accident involve death to Virginia Sorensen? Answer, yes. Dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Leanna Owen? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Tamara Durand? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jane Kulik? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Wilhelm Hospital? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 75 of the information, dated today's date and signed by the foreperson.
One more.
We, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information, dated today's date and signed by the foreperson.
There it is, clean sweep. Guilty on all charges. As he should be.
Mr. Brooks, would you like me to poll the jury?
Oh boy, what?
Members of the jury, I'm going to ask each one of you individually to stand up, identify your number for the record, and then state whether the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first so it's a little bit easier. So juror number 11.
He looks absolutely diabolical
The
right
verdicts
here.
read in open court, or are the verdicts, let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts? Yes. Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 27. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you.
Okay, sorry to pause in the middle of that. Why does it feel like even now he's staring with the intention of trying to see some angle that he can say, oh, it was unfair because the jury had these people that, like, he's looking, everything he does, there's a reason behind it, and there's like an opportunistic way that he views it. So even now, even though the trial is completely over, I'm pretty sure he's still just looking for something to say or something to argue about. So, but yeah, he's just staring every juror down. That's
Juror number 34.
weird.
The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts? Yes. Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. I should state for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was important to have them because there are certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
Of course.
The court is still satisfied
Doesn't
with
matter.
the polling of the jurors. The court now accepts the verdicts.
I feel like,
Ladies and gentlemen,
hold on.
on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case.
Absolutely.
Your service in this case is now concluded. There is no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go.
Man, that is
All rise for the
amazing.
jury, please.
I'm surprised he's still even standing up right now. I thought that he would just throw a complete tantrum. But that is so amazing. I would give a round of applause right now if people weren't sleeping around me. I'm all laughs right now because this is it. I feel like he was staring at each juror as well,
I think you'd be seated.
hoping that they would say
State at
no
this time.
or something.
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. Court will also revoke bond. In this case, I plan on bringing the case in Monday, this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf. If so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon calendar.
Judge,
Okay.
would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Okay, thank you. That
You're welcome.
helps us in our planning.
All right. All right then. Thank you, everyone. We are adjourned for today. We'll see you all on Monday.
Where's the subject matter jurisdiction? It's not being it wasn't proven for the record though, right, Darrell? He's not screaming anymore. He did not scream it. That was very uncharacteristic of him. I guess the bubble has been popped or whatever. I don't even know. I don't know how to talk right now. I'm just happy. This video has a lot of footage left, so I'm gonna skip over to see if something else happens. Look, first of all, I just want to say thank you to everyone. The lead up to this moment, this is what I was waiting to see. I'm so serious. If I could give a round of applause right now, I would. Because we finally get the end result, which is him being told that it's over, none of it worked. And we got a nice prison cell prepared just for you. But either way, look, I'm gonna skip over just to see if there's something else, so I'll be back in 1 second.
Good afternoon, everyone. We're here to have a press conference to discuss some of the events that happened today. Speaking today will be District Attorney Sue Opper, Chief Dan Thompson of the Waukesha Police Department, also David Sorensen, which is the husband of Virginia Ginny Sorensen, Tyler Pudliner, he's a Waukesha South band member, and Amber Conkey, a mother of one of the juvenile victims. Also present with us today is County Executive Paul Farrell, the prosecution team consisting of Leslie Basie, Zach Witchow, Detective Tom Casey from the Waukesha Police Department, Detective Ryan Rugland from the Waukesha Sheriff's Office, and paralegal Christy Giese. Also to my right, your left, is Jen Dunn and Carrie Peterson from the Waukesha County District Attorney Victim Witness, and with our comfort dog Pepper, who have played an integral role with our crime victims throughout this whole process. To that, Sue Opper.
I've been waiting to hear their opinion on all this.
Thank you.
Okay.
First and foremost, our thoughts and concerns remain with the victims involved in this tragedy and their families. Although the defendant devastated our community, the people of the city of Waukesha, Waukesha County, and beyond demonstrated tremendous resiliency. We are so grateful for the first responders, citizens, and medical professionals who sprang into action and immediately rendered aid and saved so many lives that day. We appreciate the jury for their work and dedication to justice. We commend the police officers and citizen witnesses who testified or were prepared to testify and asked to relive the events of that horrific day. We are satisfied that this defendant has been held accountable for his actions. He now faces imprisonment of 6 consecutive life sentences plus 859 years of confinement.
Nice.
There is much healing ahead for the victims and for our community, but we hope today's result is a step further along that path. Remain strong, Waukesha. Thank you.
Waukesha Police Chief Dan Thompson.
Thank you. 2 days we'll never forget. November 21 of 2021, on that tragic day, and October 26th of 2022. Why October 26th? Because justice was served today. I want to say thank you and praises to this community. I want to say thank you in the resiliency and strength of the families and victims who were involved in it and were impacted by this event. The investigation team, I want to send a personal thank you to the District Attorney's Office, Sue Opper, Leslie, Zach, and everyone on that team who assisted in this successful prosecution. I want to say thank you to the jury and the court process and the court proceedings and everyone that was involved in the court who found this defendant guilty, which is just and right. That defendant's actions did not define this great community. It refined us in our resolve and our strength in being Waukesha strong. Thank you.
David.
All right.
Thank you. I'm David Sorensen. These are my 2 sons.
Oh, man.
Justice was served for my wife, Virginia Sorensen, my 3 children, and the whole Sorensen clan. Thank you very much to the people that did this court case. We appreciate it. Sean or Marshall wants to say one little thing.
We've been praying for this day for a long time, and this morning my 5-year-old daughter came up to me and handed me this necklace with my mom's ashes in it, and she told me to take my mom with us for the sentencing. So she was with us today, and I just want to thank everyone for what they did today. And one last thing, my mom always used to tell us when we were kids in our family that she always said angels watch.
Absolutely.
So I just want to say angels watch over you guys and turn on those blue lights tonight.
Absolutely. Beautiful.
I want to first thank the prosecution team. They were the one that got us to this point. I'm thankful for all their support along the way and getting us to this day. It's been a difficult day. I know that this will give us healing. This is another step forward in this process. We've been resilient all the way through. One of the things that I've said so much throughout this is that we're stronger than him, and it's been proven today. It's just another step forward in the process. So I want to thank Sue, Zach, Leslie, all those guys for their hard work, Jen and her staff, and especially those first responders that has been brought up. They are the ones that especially kept me here, gave us a second chance, and they've kept our community strong. So yeah, Waukesha strong. As Marshall said, he touched on it. Keep those blue lights on tonight. Thank you, everybody.
Amber.
Just want to say that I'm very happy with the verdicts and that, you know, justice has been served today. I would just like to thank everybody, the first responders, the DA and the judge, all the law enforcement everybody who was involved, especially those who were very much involved with my family and the support system that we have had. It's been amazing to see how wonderful this community has been to pull together for all of those who were hurt that night.
Thank you. With that, we'll take a few questions. Those available for questions will be Chief Thompson and District Attorney Sue Opper. So I'll start right here, TMJ4. Who would you like to direct your question to? Sue, come on.
All right.
We just got to know, how are you and your team feeling right now about this outcome?
Well, it's obviously quite satisfying that Mr. Brooks has been found guilty and held accountable for his actions. As many of these victims have said, this is a joyous day for that reason. It's also the point where we hope everyone can move on from. The support that we've gotten as this case wore on day after day was tremendous, and we're very relieved. I guess that's the best word, is relief.
Hillary?
I saw you get a tear in your eye when they were talking about Virginia's ashes. You spoke about what this meant to you and the victims. How do you begin to describe what it was like going up against Brooks as defending him, representing himself? Did that change your strategy? How did you get through all that?
Yeah. I mean, legally it changed our strategy, certainly, because if there's an appeal, we have to do, he can make a mistake in the courtroom and get a new trial, and we have to pay the price for that, we, the state.
Very true.
Victims. So it's changed our strategy in that we had to make sure, and Judge Darrell did as well, the record was very thorough, very complete, and we didn't miss anything. But as far as handling the actual court proceedings, we felt very, very offended by his behavior, his disrespect of the court, the decorum, the families, his insulting the judge, his challenging the judge. That's not the way our system is designed. That was intentional on his part. We truly believe that. He did everything he can except claim that the dog ate his homework. And he tried to turn this into his story. Let's talk about Mr. Brooks and his family. And we just kept redirecting it back to the real focus here is our families, our victims, our community, and his responsibility for this destruction.
Okay, so sorry to pause on it because there's really no reason for me to cut in at this point, but it's just good to finally hear her perspective of what was going on, even though we knew from the jump, like, they must feel as if this is an added layer of pressure dealing with somebody that's representing themselves, and he could say something or do something because the guy's already unhinged, and he could do something that starts this entire process over again just for that reason. And now the victims have to deal with this, like, they have to deal with seeing him again, and, like, I don't know. So I'm just happy to finally hear her perspective of it. And yeah.
58.
What was the most challenging part, and how did you keep your patience through all of it?
Again, it wasn't a difficult case factually, and I don't mean to sound overly confident in that, but this case was unique because the activity was videotaped, right? And so whereas most cases we have to rely on eyewitness accounts or other ways to prove the case, we had videograph evidence of his behavior all up and down that crime scene and throughout the neighborhood. So that way it wasn't difficult. Again, the difficulty and the challenges we faced was what nonsense was going to come out of his mouth next, and we were anticipating much of what would come next and being ready legally with case law and legal authority to be able to respond to that. So I think that was the hardest thing. The investigation was so thorough, so well done that we knew the facts were solid. It was just making sure the record and the presentation was done legally accurate.
We'll do Fox Local.
So what went into your decision to perhaps minimize the number of direct witnesses that went up on that stand? And I wonder, did you expect any of these antics, and if that went into your decision?
Yes, it did. So obviously we didn't know until very late that he'd be representing himself. But we as a team set out from day one, and this was months and months ago when he still had attorneys, we vowed we would not put children on the stand. Absolutely. It wasn't necessary. Again, there were plenty of other ways to tell this story without asking a child to testify in a courtroom and relive this very, very extreme tragic situation. So that was a commitment we made as a team months ago, and we stuck by that. Certainly, as we learned his antics, we reevaluated, and we would discuss it every night as a team, is who are we going to use tomorrow, and do we really need this person? Because we were so, again, not personally offended, but professionally offended that he would insult the process and insult the victims, accuse them of financial gain for their testimony, things like that. It was just so offensive that we definitely were conscious of that in our decision making, and how can we minimize this for the best of everyone, but still provide a compelling story. So yes.
Oh, okay. My bad. I thought she was done, but what I was just going to say is definitely one of the dumbest parts of this was him saying that they took money to testify against him when he physically harmed them and also injured their family members. So there's no incentive needed when you directly hurt somebody, but okay.
It did definitely play a factor.
Court TV.
Thank you so much. Ms. Hopper, there were so many victims' families inside the courtroom every day sitting behind you. How much did that motivate you and your team and how you present your evidence and your closing argument? You mentioned them. And have you been able to speak to any of them that aren't here that maybe said something to you afterwards?
Yes. The motivation we received from those families was tremendous. And we knew, again, from the point when Mr. Brooks chose to represent himself, this was going to be a marathon. We talked about that many times as a team, that we just need to keep moving forward every day, whatever that looked like. But what motivated us was these families that are behind me, a lot of them. And we thought of those mothers and fathers sitting in hospital rooms with their children and the ongoing care that they're still physically healing from and certainly emotionally healing from. And that motivated us tremendously. But you couldn't meet a nicer group of people. I mean, that's the thing, is I'm not surprised, having lived in Waukesha for 35 years, that they're good people here. And they would ask us, how are you doing? Do you guys need anything? Which was really phenomenal. They were a tremendous group of people to work for, and it was our honor to represent them and be a voice for them in the court.
Andrew Brandon, West Metro News. Yesterday it seemed you threw Darrell Brooks a little bit of a lifeline when it came to presenting his closing argument. It seemed that the judge was going to kind of forfeit his right to do that. What made you go that route to allow him and then just object to what he was saying?
That was strategic for the appeal, to be very blunt. I wasn't throwing a lifeline to Mr. Brooks. I really had no interest in hearing what he had to say because I heard all of his lies and stories so far. So that was just trying to do what was legally required at the moment. And I frankly wasn't sure it was going to work because he was so difficult with Judge Darrell. But in the end, it did work. He got to blurt out what he wanted to blurt, and then the judge struck that from the record and we were able to move on. So I was glad that that was the result, but we talked about it at the prosecution table and came up with that idea of let's offer this, again, just to protect the record for the appeal.
Great idea.
What you knew going into this with Brooks representing himself, what caught you by surprise when he presented?
Again, his absolute disrespect and dishonor to the victims, the community, and the court process.
I'll do Brian from the Freeman, and then two more we'll do CBS, and then And then, where are you from? Okay. Those are the last three. So go, Brian, you got one?
Yeah, there's been some discussion since the verdict was announced that perhaps the decision to represent himself is grounds for appeal. Are you concerned at all about that?
Well, Mr. Brooks has a right to an appeal. Every defendant does. And I fully expect him to take advantage of his rights as a convicted defendant in this case. I am very confident in the record that Judge Darrell made and his decision to represent himself. Yes.
Go ahead.
Hi, I'm Roxanne, CBS News. What do you think about the length of time that the jury took to deliberate? Short, long, were you surprised?
We were not. We talked about it last night, and frankly, I know a lot of you were here too. We were all, by the time we got to that 8 o'clock mark, we were exhausted. And when they said they wanted to go home and rest, we were thankful, quite frankly, because we all felt the same way. It's such an emotionally draining day. And to get through all that and the nonstop banter from Mr. Brooks, it's taxing. You all witnessed it yourself. So we were grateful. We thought they gave it good thought because they went out around 6:30. Their dinner was there immediately, right? So jurors are human beings. They get a nice meal. They got a little time to talk, and then they decided, let's rest. Let's sleep on it. Always a good option for decision-making for anybody, right? Get a good night's sleep on it, and come back the next day. And then, they worked again for about another hour this morning, and with the quality of the investigation in this case, we think the verdict was fair. The timing was spot on.
WR, go ahead.
There's a lot of people who aren't here today, of course, but a lot of people who are also at the parade on the day of the parade who aren't here. In closing, what do you want to say to them just at the end of this process?
Well, I hope some of you caught the flavor of that. You cannot imagine until you saw some of those videos how horrific it would have been to stand there and watch that. Especially when your children, and some of these witnesses testified to that, they couldn't find their children, right? And that's not just people who were struck. That there was many citizens who could not find their own child for a period of time. So just unbelievable. But once the car went through and everybody had that initial, the way the citizens of this community punched in. There's no other word for it. The nurses, the doctors, the EMTs, the paramedics, anybody who knew anything about how to apply a Band-Aid walked into that street and treated those people. So that was another source of strength for us, right? Is if they could do that, we can get through this.
Thank you. As we move on to the next phases of the judicial process, I'm sure that people will be readily available to provide comment as we get into, we have a court hearing on Monday at 1 o'clock, I believe, for scheduling, and I think then we're going to go into the sentencing phase, and we'll know more about that. People here behind me will make themselves available for you, I'm pretty much sure, as this goes on. But as of right now, we're going to end it and allow people to be with their families, and definitely this prosecution team needs some much-needed rest and some time away from this courthouse. So thank you all very much for being here today.
All right. Okay, so I was going to pause right there, but I wanted to let the rest of this play through. When she mentioned that anybody that worked in the medical field that was attending the parade immediately jumped in and started helping people is absolutely true, because the amount of people that you hear were off-duty cops. Some of them were nurses that were off that day and they were just there with their kids, and they just jumped in and started helping people like right away. And that's something that I forgot to even acknowledge. I'm pretty sure I didn't acknowledge it. Definitely something I'm pretty sure saved lives that day. And, we're able to buy some time for when ambulances were able to come, because I'm sure they couldn't immediately get through. I've said it before, I'll say it again. I have nothing but absolute respect for everybody in the Waukesha community, because after seeing this, I'm so serious. The courage, resilience, the ability to remain calm, to let this entire process play out, and we get to this point. I know that we had like one outburst at the end, but who wouldn't, considering what this dude has done the entire time? I have a lot of people in my comments that are from Waukesha. And you guys leave the sweetest comments. You guys are always supporting the videos and you're telling me that you enjoy them, which is another reason why I continue. I think I mentioned this at one point. I felt a little bit strange reacting to this kind of content just because of the nature of what happened. And then when I saw people in my comments from the community that were saying, hey, we like these, keep going, and we will definitely support it, is the main reason why I kept doing this. So thank you to every one of you, and thank you to everybody across the world, because there's people from other countries, other states in America that are watching this. You guys know how much I appreciate this, but I'm gonna keep saying it every time. It may be annoying, I'm gonna keep saying it. Thank you to every one of you. I love you, God bless you, and I am all smiles now. This just made my night, you know? This already happened. This happened, I believe this happened like a couple years ago. Right now, I'm just happy that we are at this point. This dude's gonna rot in prison as he deserves. And so, look, I don't have anything else to say other than thank you all. I hope you did something good for somebody today. Oh, wait, I almost forgot. If you enjoyed the video, please like, share, and subscribe. I hope you did something good for somebody today, and I hope somebody did something good for you. And I will catch you all in the next one.